All right. So good morning. So this is I want to start doing a little more question and answer for you guys. I had a client who contacted me and said, their question was, what's my basis? I inherited some property, and it came from an irrevocable trust, a trust that couldn't be revoked or changed. And generally, the answer to that is, and again, I start by saying I'm not an attorney. I am a CPA, but facts and circumstances matter. So don't take this as general advice or as specific advice. It's just general in nature. It hopefully will prepare you to get the documents you need handy. Talk to a CPA and or a tax attorney, someone like that. But here's my answer. I know my client's details. I know his specifics. And in his situation, it was a trust. They inherited the property from the father-in-law. Irrevocable trust. Why he did this trust in Texas, I don't know. Different states have different probate processes, and some states are, easier to probate a will than others. So let's leave it at that. That's for the attorneys. Get a good attorney. But my answer to him was, did the estate or did the trust, was it valued on his estate probate? When you probated his will, was the value of those assets that were in the trust, was it included in his value? The answer was no, and I knew it wasn't. Typically, those irrevocable trusts are done for many reasons, but one of them is shelter assets, protect assets. They do it in Medicare, Medicaid planning, all sorts of estate planning reasons. But generally, and this is generally, if those assets pass outside of the estate, when the deceased person passes, those assets are not included in that deceased person's inventory of assets, then you don't get a stepped up basis. My client's basis in that land that he inherited was the basis to the trust, and that was the individual who contributed that land to the trust. So you see the problem. This is land that's been in this trust for 40 years, and the guy inherited it from his parents, the grantor, the person who put the land in the trust. So you see how simply forming a trust just to be either avoiding creditors, or you see some ad on TV, and you think, oh, that's a great idea. I see these Facebook things that pop up all the time, and it's something along those lines. Hey, don't own anything. Yeah, that may be good in one instance, but in another it may be bad. So you sort of have to weigh the benefits and the cost of doing that. Because what happened was the father, let's call him the father, put these assets in trust. He inherited the land. He put it in trust. Irrevocable trust, either to protect from a spouse in the case of a divorce, protect from creditors, to get out of his estate for estate purposes, which I don't believe that's the case, or to get it out of his name in the event that he needed Medicaid for long-term care. Whatever the reason, he put it into this irrevocable trust thinking, hey, this is the great thing to do. And it may have been. It turned out he didn't need it for any of that. Now what happens is the land sits there with an old cost basis. The new beneficiary that just inherited the land, guess what? If they sell the land, they've got this huge gain because that asset passed outside of trust, outside of probate, and does not get a stepped up basis. So to calculate your gain, for those of you who follow me or listen to me, you already know what basis is, but to calculate your gain, if you inherit a piece of property and it goes through someone's estate, you get a stepped up basis. So you sell the $2 million worth of real estate for fair value. It was valued on that person's estate for $2 million. There's no gain. You inherit $2 million. You put $2 million in your pocket upon the sale. You inherit that from a trust, and it's a $2 million piece of property with $1 million cost basis, or $1 million basis to the guy that put it in the trust. Yeah, now you've just created $1 million tax liability to the person who receives the property. Yeah, I told my client it could be worse. Be glad you've got the inheritance. Be glad you received that. But just with some planning, just if the father would have sat down with an attorney or CPA, and I don't know that he didn't. He may have had other reasons for doing this. But that's the importance before you go jumping into trust and grantor trust, irrevocable, revocable trust, and all these living trusts and dynasty trusts. Define a goal, meet with accountants or CPA, meet with tax attorneys or estate planners. Do that, please, because you may find out that you jumping through all of these hoops just to create what you think is a good thing may not be. And it may not accomplish any of your goals. Your goals may, the design of the trust may never come to fruition. I see people that start corporations and LLCs all the time. And then they do all of these things that go against the whole reason of forming that liability protection. So just because something exists in form doesn't necessarily mean it's great, number one, or even good. And it doesn't necessarily guarantee that it accomplishes your goals. So I just wanted to throw that question out there. I'm going to throw many more questions as I get things during the day. I want to provide those to you. So, take it or leave it. Either you can utilize this or not. But I appreciate you watching.